be punctual. It is said that punctuality is a virtue of royalty. And today we welcome good afternoon, participants. Because punctuality is a virtue for royalty too, we too today talking about the constitutional monarchy, Westminster Model, issues arising when constitutional transitions, or rather transitions in political regime takes place, and the constitutions comes alive, the provision, with a intense focus on constitutional organs having to discharge their various responsibilities. To all of us who are citizenry, whether lawyers, stakeholders, judiciary, observers of political life, we are concerned. We are concerned that this document called the Federal Constitution guides and provide the benchmark for us to assess decisions that are made during such transitions. It is through such that we begin to find a more accentuated understanding of the provisions. Indeed, it is so. The lively discussion in the media, both mainstream and even social media commentary, open-ed pieces, have shown that constitutional issues are not only the provenance for us at forums like this, but vitally involve all stakeholders. There were even Broking House, which sponsored lectures, which both Shad and myself took part in, which involve the business and commercial world. This is so, and this is right, because the Constitution is not only meant for constitutional lawyers. It does matter, or does it not? That is the primary question we are asking. This afternoon, we are privileged to have with us one of the doyen, and I use the word measuredly, who has thought hard about the journey of our Malaysian Constitution, the precursor, of course, the Malayan one. Andrew Harding is no stranger, that phrase well worn and well used, to the shores of Semenanjung, Malaysia. And he has written copiously on this issue, both in the past and on recent times. We are indeed privileged that today Professor Andrew Harding is willing to spend his valuable late afternoon sharing with us his personal and intellectual journey on a vital topic, which is the role of the constitutional monarch, and brief observations about the so-called Westminster Model. Andrew Harding hails from NUS currently. If I were to list out his various other institutions, it will take us another 30 minutes. So I leave it to you to read the bio data. The proof is in the pudding, of which we will soon be partaking. So we are very pleased. Over to you, Professor Andrew Harding.
Right, thank you very much, Philip. And it's a great pleasure and a great privilege to join you this afternoon. So you talked about pudding. Here is the pudding, or the beginning of the pudding. I hope I won't take too long over this, because I think we've got some very, very interesting issues that are worth discussing between us. But I want to just give an overview of some of the issues relating to the role of the constitutional monarchy at this very important juncture in time, because obviously in the last 3 years or so, the monarchy has become perhaps even more important than it has been in the past. Right. So I wanted to just start with a bit of history under the title "History is Identity," which I do believe is the case. And sorry if a lot of this is familiar to most of you, but perhaps not everybody in the room, so we'll just run quickly over this. But I want to talk about the history because when I come to assess the present situation of the monarchy, I think it's very important to understand just how significant this issue of identity resting on history actually is. And these Malay monarchies, the 9 of them, as you know, go back a long way. They derived from the Malacca Empire, and modern Malay states were created after 1511 for the most part. And of course, during that period, right up until constitutional law was kind of gradually introduced over the last 150 years or so, and the traditional monarchy was absolute. I actually put that in inverted commas because I don't really believe that there is such a thing as an absolute monarchy, because there are always some restrictions and checks on monarchy, even if they are not spelled out in a written constitution. So there were no institutional checks, but for example, the consent of territorial chiefs was required for major innovations, such as the signing of the Pancor engagement in 1874. So during that period, 1874 to 1920s, treaties were concluded between the British government, the Crown, and the various states, the 9 states, introducing what is called the residential system, under which rulers were supposed to act on the residents' advice, except for matters of custom and religion. So the whole idea of a head of state acting on advice actually goes back this far. It goes back way before the 1957 Constitution, and it's something that is quite deeply rooted in history, but obviously with major exception matters of custom and religion. Moving very swiftly forward to 1946, you will recall the crisis over the Malayan Union, where the British government attempted to abolish the Malay monarchies, and there was a lot of pushback, obviously, from Malays, saying that this was a kind of cultural desecration, and even a lot of British officials joined that rebellion. And this resulted in the Federation of Malaya in 1948. And I think the important lesson from this is that in Malaysia, federalism and monarchy go together. It's difficult to imagine the monarchies without the states. It's difficult to imagine the states without the monarchies. And so I think they're kind of mutually supporting concepts in Malaysian constitutionalism. And then, of course, the Merdeka Constitution 1957, the powers and privileges of the rulers were specifically retained in that constitution. And of course, what we think of as the so-called Westminster Conventions, such as acting on advice and so on, were entrenched in the Constitution at that time. And also, Schedule 8 of the Constitution required the state constitutions also to adhere to these Westminster conventions. So there's a kind of a holographic kind of way in which these conventions kind of can be seen right through constitutionalism at all levels in Malaysia, a bit like Brighton Rock, where you can break the rock in half and you can still see Brighton Rock inside it. Now, you may be interested to know here, I mean, I know a number of you would have known Hugh Hickling, who of course was a great expert on the Malaysian Constitution and was involved in the drafting process. And I found it interesting to revisit a disagreement that Hickling and I had a long time ago. I mean, it's nearly 40 years ago, when Hickling wrote an article in 1975. If you're interested, both of these articles are published in the Malaya Law Review. And he argued that the powers of the rulers lay outside the constitutional text. And I want to come back to this idea of lying outside the text, as well as, of course, within it. And he emphasized the persistence of social and cultural norms, referring to Malay culture and the long history of 500 years of monarchy in these 9 states. And of course, then you have Article 181, subsection 1, which says sovereignty, prerogative, powers, and jurisdiction of the rulers within their respective territories, as hitherto had and enjoyed, shall remain unaffected. Now, I came along in 1983 and argued to the opposite effect. I mean, I said that the royal prerogative had, in effect, been codified by the Constitution. In other words, the Constitution was supposed to be a complete statement of the prerogatives of the rulers. And further, that if you actually seek to find constitutional powers that lie outside the text, then you're confronted with a serious logical problem, because where is the end to the concept of royal powers, royal prerogative? If they are not confined within the text, then within what are they being confined? Or maybe they're not even confined at all. They could just expand in a limitless way. I revisit this, not to argue that that I was right in what I said. In fact, I think I will say in a moment, there's a great deal in what Hugh Hickling said, but I'm still troubled by this idea of the conceptual stop. So this kind of leads to the question, what is the correct interpretation of the constitutional conventions with regard to the Prime Minister's appointment, for example, acting on advice, the royal consent, that sort of thing. And obviously, this issue of correct interpretation has been very much discussed in the last few years by, I mean, a lot of the people present and a lot of people in the media and so on. It's been a constant focus of attention. So this is a really serious question to which we don't have any easy answer. But I'm going to put forward a few propositions. I'm still somewhat in 3 or 4 minds about this issue myself, so I think we can valuably have discussion over how to interpret these conventions. So moving on, after independence, there were a number of conflicts over the powers of the rulers, and many of you will remember, if you were around at the time, that there was a big crisis over royal assent in 1983-4, where the government tried to sort of codify or restrict the royal assent because of occasions where rulers had simply refused or failed to give assent to bills that had been passed in the assembly at the state level. And there were worries about the impending Yang di-Pertuan Agong, who was the Sultan of Johor at the time, and what he might do with royal powers during the currency of the BN government. Ultimately, the Prime Minister backed down over this amendment for complex reasons we don't need to go into. But ultimately, as a result of a further amendment in 1993, the royal assent has in fact been codified in Articles 40 and 66. So if the Agong does not assent to a bill, then it will become law automatically after a period of 30 days. So it doesn't matter if the Agong doesn't actually sign the bill, it can become law anyway. Otherwise, of course, if the bill requires the consent of the Conference of Rulers, that's a different matter. Now, an interesting point about 1984 is that on the subject of emergency powers, which was another concern of the government, the Prime Minister failed to secure the vesting of power to proclaim an emergency in the Prime Minister personally. And this was as a result of pushback from the rulers. Now, I'm going to talk a bit about the idea of upholding the Constitution. And this, I think, is an example of how, in a positive way, the rulers can exercise their influence to ensure, in this instance, that not too much power was given to the Prime Minister personally. So it has remained the position that the Agong acts on advice in this matter. We'll come back to that as well. But the advice is coming with the assent of the cabinet, not the Prime Minister personally. And I think that's extremely important, because by proclaiming an emergency, the Prime Minister could become a dictator in a very personal sense. So that was a good intervention pushed back by the rulers on that occasion. And then in 1993, there was a crisis over the sovereign immunity when a number of rulers had breached laws and there was no way of bringing them to account because you couldn't sue any of the rulers in the ordinary courts. You couldn't bring them up on criminal charges either. And I think some of you will know the sort of occasions which led to this particular constitutional amendment, which we don't need to go into, but it resulted in a constitutional amendment to introduce the special court in which cases can be brought against the rulers, both criminal and civil, but there are some limitations. For example, you need the assent of the Attorney General to bring a case in that court, and there have been a couple of cases brought in the special court over this span of 30 years or so since it was introduced. Now, these crises, of course, did not deal with the appointment of the Prime Minister, nor did they deal with the issue of acting on advice. But of course, the Constitution does say that the Agong is required to act on advice, but we'll have to discuss what that actually means in practice. So problems had occurred quite frequently at the state level involving the exercise of royal powers. But at this point, nothing really had happened at the federal level, but that was going to change as a result of changes in the political system. In 2008, there was an election in which the BN won by a very narrow margin. And so you saw the emergence of a two-party system, and that really potentially brings into play the power of the Agong to appoint the Prime Minister. And of course, that's what we've seen happening controversially in the last few years. There was a bit of a foretaste of this because, again, many of you will remember the Perak government crisis in 2009, which was ultimately resolved by the federal court in the case of Nizar and Zambri, where they affirmed the power of the ruler to dismiss the chief minister, even though it was not stated in the state constitution that the ruler had the power to dismiss the sitting chief minister. Had the power of appointment, but there was no express power of dismissal. But when the chief minister was dismissed on grounds of lack of support of the majority of the members of the assembly, the court said that that was a proper exercise of powers, and that the ruler could resort to extra legislature evidence in order to decide on matters of confidence. And that obviously is a very important decision with important ramifications. Now, we now see, as a result of these various crises, I think a very different kind of monarchy to what we have seen previously. And I think it could be that the restrictions that were introduced by constitutional amendments in the 80s and 90s did signal that the system as a whole was not happy with misbehavior on the part of rulers, whether at a personal or at a constitutional level. And Prime Minister Mahathir, who was the one behind these constitutional amendments, stepped down in 2003. And then we see this emergence of a kind of a new theory of monarchy. I know some will claim that this is not a new theory, but it's an old theory. And I see Philip knows exactly what I mean by that. We can debate that, but it has been presented by a number of observers as a new theory. And I think it's well represented by this paragraph from a speech by Sultan Nazrin of Perak, where he said, "The king is not a monumental ornament without life, without soul. Everything that happens is in the vision and hearing of the king. It is a mistake to think that the role of a constitutional monarch is just like a president, limited to what is written in the constitution. The role of the constitutional monarch is beyond what is contained in the constitution." So this is a very strong vindication of, if you like, the Hickling view of the royal prerogative. And it's interesting that the Sultan compares the position of the rulers with that of a president. In other words, he's saying the president is a creature of the constitution, but the rulers are not a creature of the constitution. The rulers are a creature of history and tradition and custom and social status. And that's an important distinction. So he wants to go beyond the constitutional text. And of course, if you believe this theory, then you can easily rationalize what happened in 2009 to say that, well, the ruler doesn't need to just exercise powers that are specifically set out in the Constitution. He can go beyond those and exercise what might variously be called, the right to uphold the Constitution or reserve powers which are out of the ordinary exercise, the ordinary kind of use of the Westminster conventions. So since 2003, the status of the ruler seems to have revived, and their role seems to have, if anything, expanded. Perhaps, as I say, this is related to improved behavior. And I think the rulers have gone out of their way to show the public that they have substantial merits as individuals as well as a group, so that they have this superior public status. Now, if you're worried that I'm playing fast and loose with public opinion here, let me point to a research exercise coming out of the Institute of Southeast Asian Studies in Singapore, which showed that 75% of Johorians approve of occasional royal interference in politics. And if you go back to October 2020, remember when the Agong refused to proclaim an emergency. He did not act on the advice of the Prime Minister in requesting the proclamation of emergency. He refused to do that. He consulted the Conference of Rulers before he did so. And that exercise of royal power, I think clearly garnered the support of an overwhelming majority of the public, who praised the Agong for preserving democracy, because Parliament would have been suspended if an emergency had been proclaimed, but also because he tried to preserve the health of the public by telling the government to carry on with the good work using existing laws to counter the COVID-19 pandemic. So that was really, the exercise of royal power at its most publicly prominent and ascended to. Now, very interestingly, a scholar whom I work with, Harshan Kumarasingham, who works on constitutional history at the Commonwealth level, has identified Malaysia, along with a number of other Asian countries, as representing what he calls Eastminsters. In other words, these are originally Westminster systems, where we have to regard the constitutional conventions as going beyond the way in which they are conventionally interpreted. And I think that if he were here, he would point to some of the things that I have already mentioned and will mention as examples of this kind of Eastminster. So it's kind of like Westminster, but it's not quite like Westminster, because the conventions are interpreted in particular ways that are not really consistent with the way those conventions are interpreted in, for example, the UK, Australia, Canada, and some other countries. And this scholarship talks about Pakistan and India and quite a number of other countries, not just Malaysia. So what I think we can see happening during the last 3 years is what you might call an expansion of this Eastminster. Let's look briefly. This will all be very familiar to you because you've lived through these events, but let's just look at them from the point of view of these conventions and the idea of Eastminster, Westminster. There have been 3 prime ministerial appointments during this period. As you'll recall, after the election in May 2018, the Agong delayed the appointment after the result of the election was known. Some people were quite worried about that and wondered why the appointment was not taking place. But eventually, on the same day as the election results, officials prevailed upon the Agong to appoint Tun Mahathir as the Prime Minister. And that was, I suppose, just within the Westminster Conventions, because it became clear that Tun Mahathir had the confidence of a majority of the recently elected members of Parliament. They all signed a letter and so on. There was a bit of kind of overkill to prove that this was the case, but at least eventually the convention was complied with and Mahathir was appointed late on that day. But then the powers of the Agong came into question again in March 2001 and 2021, when you'll remember that the Agong, well, first of all, Tun Mahathir resigned as Prime Minister and was then appointed as interim Prime Minister, pending a bit later the appointment of Tan Sri Muhyiddin as Prime Minister. There is, of course, no such office as interim Prime Minister in the Constitution. And so arguably here, the Agong had gone beyond the text and beyond the convention, because conventionally in Westminster systems, there's no such thing, formally speaking, as an interim Prime Minister. It's just a kind of a political description of a situation where the Prime Minister continues in office until his or her successor can be chosen. So, for example, Theresa May in the UK in 2019 was in office for, I think, about 7 weeks, pending the appointment of Boris Johnson, because there had to be an internal election in the Conservative Party. That's the sort of thing that happens. And as you know, he also interviewed all members of Parliament in order to ascertain where their support lay. He couldn't get the answer from that, but after speaking with the Conference of Rulers, speaking with the party leaders, he appointed Muhyiddin as the Prime Minister. But the interesting point here is that there had been no event in Parliament indicating loss of confidence in Mahathir or confidence in Muhyiddin as the next Prime Minister. And in fact, that situation, quite shockingly, continued right through the 18 months or so of Muhyiddin's premiership. There was never an affirmative or negative confidence debate or motion debate or vote in Parliament during that time. And that seems to be astonishing in terms of kind of orthodox Westminster constitutionalism. And then, as you know, the same sort of thing happened again just last August, when again the Agong interviewed all the members of Parliament before making his decision. And again, there had been no event indicating confidence or the lack of it in Parliament during that time. So we now have we have precedents, we have practice showing that the Agong does not have to base his decision on what happens in Parliament, but can interview party leaders, can interview members of Parliament, all of them individually, in order to find out where support lies. And I want to suggest I have never heard of any such process being adopted in the appointment of a Prime Minister or a Chief Minister anywhere in the Commonwealth during the period of Westminster government. So this is really a Malaysian innovation, if you like, in terms of convention. So then, speaking more generally, I mean, how do we then go about this issue of interpretation that I raised earlier? And this is a bit problematical. In the UK, for example, Professor Griffith famously stated, the Constitution is what happens. If it happens, then it is constitutionally valid. But of course, that is in a situation where you have an unwritten Constitution. But what happens when you have a written Constitution, but the powers that can be exercised also lie outside the text of that Constitution? So that it's partially written, but apparently partially unwritten as well. How do we then interpret these conventions? Do we interpret them in line with general Westminster practice, or do we interpret them in line with Malay governance traditions, and how would we define those, or in line with some kind of evolving local practice, such as the interviewing of all members of the legislature? And we have to bear in mind that although we call these constitutional conventions, they are actually written constitutional law. They are there in the Constitution. The issue I'm raising is not whether they are written or unwritten, but how they should be interpreted, right? And I think that's something on which we can have quite an interesting discussion, because on the one hand, obviously the conventions are designed to transplant Westminster style conventions into the Malaysian Constitution. That much is clear, but as everybody who talks about legal transplantation will tell you, it's not straightforward, and those transplanted rules will have to be adapted to the local context. So do we look at Westminster precedents across the Commonwealth, or do we look at local context, or how do we interpret these things? And if you were to ask, well, is there such a thing as Malaysian constitutional conventions? The answer is yes, clearly. Clearly, what is now, I think, clearly a convention is that the Agong will consult with the Conference of Rulers before making a major decision. And I can give you a whole host of reasons why he should do that. But that is clearly, I would say, a local convention. I can give you other examples. So in other words, we don't have to stick rigidly to this idea of Westminster conventions and look at British precedents or Australian precedents in order to decide how they should be interpreted. That is not necessarily the case. So let me lay down a few propositions for discussion here. The first proposition: the judiciary can clarify the meaning of these constitutional provisions. They are not non-justiciable, as has, I think, unfortunately been claimed by some authorities recently. In fact, there has been quite a large number of cases where the scope of royal discretion has been reviewed by the courts. Discretion has to be exercised within its proper legal limits. We don't necessarily question how the discretion is being exercised, but it must be exercised within its jurisdictional limits. That is a fundamental proposition of the rule of law, clearly. Secondly, Malaysia, as I have argued, does not have to follow Westminster precedents necessarily. Transplanted law has to be adapted to the local context. However, we need to be aware of why these conventions exist, what function they carry out, and see what would happen if we evolve local conventions in a particular way. So I think I would be a bit worried about the way in which conventions have been interpreted in recent years, because it seems to marginalize the position of Parliament in the constitutional system. Thirdly, these conventions, as I argue, have in fact emerged. Whether we agree or not, it is a fact that they have emerged. So let me draw this to a close, and I hope, Philip, I haven't taken too much time over this, but this is the end of what I wanted to say. In the light of all this, do the conventions regarding the rulers need to be codified? Now, I think there's a big problem here, because if the answer to that were to be yes, if you thought that yes, we should codify all this because it's too uncertain, we don't know how rulers are going to behave in the future, they can do anything they like, there's no check or balance, then okay, you may be right about this, but you'd still have to answer the question, why would such codified powers be regarded as exhaustive? Because the powers are already codified in the Constitution, but apparently they're not regarded as exhaustive. So I want to suggest that however much you codify the powers, there's always going to be something outside the text. And that, I think, is just a fact of political life, which you're going to have a great deal of difficulty getting round. Secondly, how would you reach agreement on what the codified text should say? that is going to be an enormous argument, which I think is going to take probably years to resolve. I'm not sure it's worth setting foot on this particular path. The operation of constitutional conventions has always been implicit rather than explicit. They've never been really subject to detailed rules, just general political propositions, not detailed explanations of how conventions are supposed to be operated. That's just left to practice to evolve over a period of time and according to the understanding of the people involved, the actors, and also changing times, because conventions do evolve over a period of time. So perhaps some clarification by standard operating procedures might be helpful. There have been mistakes made by rulers. I think one could say the governor of Sabah made a couple of mistakes in chief ministerial appointments in the last few years, and so there's doubt over interim appointments. Are those really possible? The role of no confidence votes, very important. And what is the evidence of support or the lack of it? So let me just leave it there. I mean, the monarchy has survived. The rulers have adapted to all sorts of changes. So I think we are stuck with this situation, but we need to remember the conceptual stop. Where does all this finish off? Okay, that's it.
Thank you.
Andrew, thank you so much. You have set a fascinating framing of the issues, especially in terms of contemporary period, which prompted the organization of these series of webinars. In particular, you have pointed out features of the role of His Majesty Yang di-Pertuan Agong in making certain decisions in recent times relating to the proclamation of emergencies or refusal of the same in October 2020, which gave rise to a number of debates, both involving the Attorney General's office releasing public opinions, or rather releasing his opinion to the public, and the debate that ensued. You have also helpfully highlighted the stress on the so-called Westminster Model, a phrase often bandied around, bandit, I don't use it in a pejorative sense, as it does not need unpacking. We all know that short phrases and concepts always need analytical clarity. And your attempt to do so in your presentation is a helpful start in what I would call a robust conversational sessions that we will be engaged on. Before we deal with the conversations, I think it may be good to have our second presenter, all right? Our Saudara Nazmi Shari, whose writings have been articulated, and for those of us privileged to access them, we have found it to be very provocative, and I use the sense of that word in a measured way, not merely polemical, but provocative, academically robust, and willingness to join in a robust defense and articulation of issues surrounding the powers, prerogatives, and the role of constitutional rulership in modern democratic governance. I give you Saudara Nazmi, and I invite him now to address us. He comes from UiTM, but he has been an active conversation partner in these forums, and we are honored today, University Malaya Law School, to invite a colleague in the academic fraternity to join in this conversation. Nazmi, over to you.
Thank you, Thank you, Professor Philip. Thank you to University Malaya for inviting me. The honor is entirely mine. And Also, the honor is also entirely mine because I'm presenting a webinar in which I'm facing people whose textbooks I've used these textbooks ever since my undergraduate days. Textbooks written by Professor Andrew Harding, Professor Kevin Tan, and Professor Salim Faruqi. So these are the demigods of constitutional law in Malaysia. So yeah, the honor is entirely mine. Not Unitarian, in fact. Okay, so if I could just share screen and how do I do this? Where is it? Okay, sorry.
It's all right, Nazim, take your time.
Okay. Share screen. Open.
Does it seem to work?
Share.
Okay, it's coming.
Okay. So, Assalamualaikum warahmatullahi wabarakatuh. Thank you for inviting me again. And selamat petang, everyone. So, in my presentation today, nothing's happening. Okay. I'll be sharing with you the problems that we face when we teach our constitutional law students regarding the powers of the Malay rulers. Because what we teach in class regarding the principle of constitutional monarchy, in which the powers of the Malay rulers are limited by the constitution and so on. But when we go outside the university, when we listen to the comments by some academics and legal practitioners, they would give a different view on what the powers of the rulers are all about. So firstly, when we talk about what we do in class, these are the authorities that we use. We have paragraph 58 on how the powers of the Yang Lieutenant Besar during that time, currently the Yang Lieutenant Agung, that he must therefore act on the advice of the minister with regard to all executive action. And this is continued further by paragraph 18 in the constitutional proposals for the Federation Law, the white paper, which we could see in our current Article 40. While that is for the Yang Lieutenant Agung, we also have similar provisions in the 8th schedule of the Federal Constitution regarding the powers of the Malay Sultans back in their home state. All in all, these provisions limit the powers of the Malay rulers and under the principle of constitutional monarchy. So these are the sources, these are the authorities that we use. However, we have a group of academics and lawyers who go around the country giving another version regarding the powers of the Malay rulers. And they say, no, the powers of the Malay rulers are above the Federal Constitution. You cannot use the Federal Constitution to limit the powers of the Malay rulers. And this is the first argument. That the powers of the Malay rulers are above the Constitution, and they also use legal theory to back this up. Unfortunately for them, because some of us do teach jurisprudence in law faculties, I'm not sure whether jurisprudence is a compulsory legal subject in all universities right now, because it's about theory. It has nothing to do with practical subjects or professional subjects for that matter. But in UiTM, it is a compulsory subject. And any student of jurisprudence could tell you that Kelsen did not say that the powers of the monarchy cannot be limited by the Constitution, because this has been the line of argument by these people. They've quoted Kelsen, and they said Kelsen said the powers of the monarch are above the Constitution. It cannot be limited by the Constitution. But when you really look at, what Kelsen wrote in his book, General Theory of Law, instead, he traced the development on the monarchy system. Well, firstly, he said, firstly, you have this system of absolute monarchy. And according to him, that absolute monarchy is a form of despotism. Next, it transformed into constitutional monarchy. And according to him, constitutional monarchy is where the power of the monarch is limited, is restricted. And finally, but no act of the monarch is valid without the counter-signature of a responsible minister. So again, I don't know how and why these people decided to misrepresent Kelsen in backing up their argument. And next, they also love quoting Austin, because Austin talked about the commands of the sovereign. It is that you are bound to follow the commands of the sovereign. But when you look into his book, the province of jurisprudence determined, this is what he said. But the governed collectively or in mass are also the superior of the monarch, who is checked in his powers. So again, Austin also allowed for the rule of the majority, the will of the people, to be the sovereign. He wasn't just referring to a monarch, to a person. He was also referring to the concept of democracy, the will of the people. So this argument is unsustainable, clearly. Next, they use this argument that the principle of constitutional monarchy is an alien concept. This is a constitutional transplant from UK. We have our own customs and traditions regarding the powers of the Malay rulers. Okay. There's a hint of civicness vulgis here, in which any legal system is derived from the culture, customs, and traditions of the community, in which custom precedes legislation. So before the argument goes this way, before you could have any kind of law, in Malaya, we already have customs and traditions regarding the powers of the Malay rulers, and they've enjoyed sovereign powers even back then. So you cannot import a legal principle like constitutional monarchy from the UK to limit their powers. Well, we cannot run away from looking at the significance of customs and traditions in any laws and legal system. I mean, that's a given point. Obviously, it is influential, it is significant. But the problem is, how far do we maintain those principles of customs and traditions in the legal system? In this respect, I think we should refer to Foucault's discourse in discontinuity, because according to him, history does not evolve in a linear progression. There will always be some points in the past in which there was a break in the so-called chain of causation. So when you look in the past, yes, you could probably argue that hundreds of years ago, the Malay rulers enjoyed all of these complete absolute sovereign powers. But history also shows that it stopped when they signed treaties with the British government, in which they agreed to accept and act upon the advice of the British resident and advisor, well, except for matters on Islam and custom of the Malays. So within those treaties signed with the British government, there was already a principle of constitutional monarchy, which they've signed and which they've already agreed back then. So there was already a break in the so-called chain of causation regarding the powers of the monarchy. I know I shouldn't be using chain of causation such as that. And yes, there is a problem between Westminster versus Eastminster, and Eastminster has been made popular not just by Dr. Kumarasingham from Edinburgh. Professor Andrew Harding has also been writing a lot of stuff on Eastminster democracy here. Yes, any constitutional transplant will not work on its own. It would be modified, and it has been modified to suit local customs. That's fine and good. But specifically, when you are looking into local conditions regarding the Malay rulers, how far has this been transformed in the mindset and the psyche of the people? And we say that it has. For example, remember what happened after the Second World War, in which the political awareness of the Malayans has changed due to the sufferings that they've gone through. And then you saw the UMNO slogan in 1948 that the monarch is the populace and the populace is the monarch. And this argument, again, failed to look into the difference between traditional constitutionalism, which depended on the absolute powers of the monarch, and on the other hand, we have now the concept of modern constitutionalism, in which it depends now on the will of the people. So again, there's a problem with this argument, and so far it is unsustainable, no matter how attractive it is. And it is attractive when you try to link the legal system with the customs and traditions of the people. But when you really examine the historical traditions of what we went through in this country, no, it is unsustainable. Sorry. Next, we have this argument that the Malay rulers granted us independence. It wasn't the British who granted us independence, it was the Malay rulers. And the Malay rulers also bestowed the legality of the Federal Constitution of Malaya. Well, unfortunately, again, for these people, when you look into the Federation of Malay Independence Act 1957, this is freely available online from the National Archives of the UK government. Section 3 of this act says, any such agreement shall be conditional upon the approval of the new federal constitution by enactments of the existing federal legislature. What it means is this: in order for independence to be bestowed to Malaya in 1957, in order for the federal constitution to be valid, they needed the approval of the representatives of the people. And we already had in 1957 a federal legislative council. And it was the approval of the members of this Federal Legislative Council that was required for this, for independence to be granted and the Federal Constitution to be valid. So Section 3 did not touch anything regarding the rulers or the Malay rulers. It talked about this. Next, there was this attempt of hair splitting between what a colony, what a British colony means and what a British protectorate means. This was made famous by Dr. Zainul Kling, or Professor Zainul Kling. Professor Zainul Kling was the previous holder of UiTM's Kerusi Institusi Raja Melayu. Well, according to Dr. Zainul Kling, who gave a press conference in 2011, this was in the midst of Muhammad Sabu's criminal defamation case regarding the Bukit Ketong incident. According to him, before independence in 1957, Malaya was not a British colony. Malaya was a British protectorate. And in the British protectorate, real power was in the hands of the local people, local traditional elites, like the sultans and so on. It was not in the hands of the British. If it is a colony, then yes, real power, everything was in the hands of the British colonial power, not the traditional elites. But then, unfortunately for Dr. Zainul Kling, somebody has pointed out that, you know, in 2005, you wrote a chapter in a book that was published by Dewan Bahasa Pustaka. In that chapter, you wrote that, you know, there is no difference between protectorate and colony. Call it by any other name, whether it was a trade, whether it was for protection, it was still a form of colonization, colonialism. So there again, there was something wrong with this analysis from Dr. Zainul Kling. And finally, even for him, earlier this year in in February, I think, while chairing an event in UiTM Shalam, he was the chair in introducing Tan Sri. There was this talk on Hadiah Peace Treaty of 1989 regarding the Malayan Communist Party. In his speech, in Dr. Zainul Kling's speech, he finally acknowledged that yes, we were colonized. So again, is it really important whether we were a colony or whether we were a British protectorate? Because when you look into literature regarding this, as pointed out by Dr. Rachel Liao, who was an ex-student of Ines Malaya, who is now teaching at the Cambridge University History Department, she pointed out that the notion that there was such a thing as indirect rule of British was false, because in reality, there is no such thing as a difference between a colony and a British protectorate. Real power was in the hands of the British. It wasn't in the hands of the local traditional elites. Okay, so this argument, the Malay was granted its independence, not the British. Again, it was unsustainable. Next, then we have this argument that the British acknowledge the British recognize and acknowledge the sovereign powers of the Malay rulers. Okay, they pointed out the privileges enjoyed by the Malay rulers in the past, and this was recognized and acknowledged by the British. So far, they have not offered a clear analysis regarding British colonialism, because many writers have written on this when they pointed out that the modus operandi of British colonialism was that there was a collaboration between the British colonial power and local native elites, whether you examine this in British Malaya or India, or even in Africa and Middle East, it was still the same thing. They collaborated with the local native elites, and the local native elites were given special privileges. But yes, the distribution of power was not fair. Power was skewed towards the interests of colonial power. But there you go. This analysis did not really dive into what British colonialism meant during those days, or how it operated. And none of these people had tackled this important issue as who was responsible for British colonialism in Malaya. And again, this is a very important point, and I believe that we have to be careful with this, because there are some people who would like to blame everything on the Malay rulers in the past. And some of us beg to differ, because power was not owned absolutely by the Malay sultans in the past, in which power was shared between the sultans and the Malay rulers. So for example, in the signing of the Pankor Treaty in 1876, it was inconceivable for the Sultan of Perak to act alone. I mean, he must have received some advice, some kind of collaboration from his own nobles, Bangsawan Melayu. So, you know, then who was really responsible for this? This wasn't really addressed by any of these people. Next, I made it a point to listen to most of these talks given to our students, and also when they're done and outside on mass media. Among their favorite talking points is this, that the British acknowledge and recognize the power of the sultans in best-selling pardons. And they love to bring out the example of the Ethel Proudlock's case. This was a murder case regarding Ethel Proudlock was the wife of the headmaster of Victoria Institution in KL. She was convicted for murder, and Sultan of Selangor pardoned her. So these academics and legal practitioners always like to use this case to show that, see, the British recognize the sovereign powers of the universe, and we should too. But unfortunately for them, because we're talking about power pardons, and what about Article 42 of the Federal Constitution? Because when you look into Article 42, Clause 4, Paragraph B, it clearly says that in bestowing pardons, the sultans have to act on the advice of the Pardons Board, meaning to say the sultan does not have an absolute discretion in giving out pardons. And this was also made clear in the High Court's decision, for example, the High Court's decision of Khairul Azam, the Buzi Azam's case, and challenging the pardons given to Anwar Ibrahim, where the High Court judge said, yes, power pardons as exercised by the sultans and it has to be exercised on the advice of the Pardons Board. So these Malay rulers do not have absolute discretion in giving out pardons. Okay, one. Number two is this, again, they love to refer to cases in previously before Merdeka, and which these cases upheld the immunity of the Malay rulers. For example, Miguel versus Sultan Johor regarding a breach of promise marriage, Duff Development, Sultan of Kelantan, and Pahang Consolidated State of Kelantan. All of these cases upheld the legal immunity of the Malay rulers. And again, the conclusion that they tried to hone on in all of these cases that, see, even the British acknowledge the sovereignty of the rulers, and this should be continued right until today, and we should acknowledge that they do have these powers and so on, and it cannot be limited by the Constitution. Again, this is weird, because whatever happens to Articles 181 and Article 182, in which in which there was an amendment to the Federal Constitution in 1993 and 1994, in which the legal immunity of the rulers has been stripped off. We have heard nothing from them regarding this point. I'm not sure whether they're ready to address this point at any point of time. If you were to observe, there were some slides, PowerPoint slides regarding this point that have been uploaded on the website of some museum, I think, which was weird because it did not deal with its authorities. Okay, so we have a problem with this, and clearly this argument falls flat and is unsustainable. Next problem when we teach the powers of the Malay rulers for our constitutional student is this, the Tujuh Wasat Raja-Raja Melayu. Okay, so actually the real authority on this issue is Professor Clive Kessler from ANU, I think, Australian National University, who has written a lot on all these issues, and I've been faithfully following his writings ever since. So this Tujuh Wasat Raja Melayu, the so-called final will and testament of the Malay rulers, this was only introduced by the Regent Tapera, as His Royal Highness was in 2009, when he officiated the release of the Malay books written by the late Professor Syed Hussein Alatas that had been translated into Malay, the third edition. So he introduced this, and according to him, well, on the 5th of August 1957, in giving the royal assent in creating the Federal Constitution of Malaya, the Malay rulers produced this wasiat. This was the will. This is what. This is very important because number one, they proclaim that the name of this new country is Tanah Melayu, and then they said that they set Islam as religion of the federation, and they provide for the protection of lands owned by the Malays and the Malay Reservation Enactment, and so on and so forth. Okay. Our problem is this, until today we have not found the original copy of this Tujuh Wasat Raja-Raja Melayu. I spent 2 days at the National Archive at Jalan Duta, currently the Jalan Tuanku Abdul Halim. I went through all the relevant files. I went through all the alhamdulillah, audio video recordings. No, couldn't find any single reference to it at all. Very interesting, in 2011, there was a national conference on this Tujuh Wasat Raja-Raja Melayu and Putrajaya, and Sultan Perak, Sultan Azim, was invited to officiate this event, and several academics were invited to present papers on this. And you have, for example, Shamrahayu, you have Dr. Wan Fauzi. Dr. Wan Fauzi is currently in University of Pahang, I think. You also have some guy from ICSIM, Dr. Wan Fauzi, Professor Teo, and then you also have Dr. Chandra Muzaffar, I think. Of all of these paper presenters during the event, only one person confessed that he had tried looking for it at the National Archive and the National Library. He couldn't find a copy of it. And I was made to understand, I was told on Facebook that a few days before the event, a few weeks before the conference, he had already alerted the Sultan regarding this finding, that he couldn't find a copy of it. But so some of these people, some of these academics, they're not really concerned with whether they don't find it important whether there is a original copy or not, because to them, look, it's there in the Federal Constitution. Unfortunately, that is not the case, because when you really look at, for example, the Malay Reserve Land Enactment, and there is already an article about this published by University Malaya Law Faculty Law Journal, University Malaya Law Journal, regarding the red letter grant regarding the Malay Reserve Land Enactment. According to the writer of that essay, and this is part of history, of course, that it was the British who came up with that Malay Reserve Land Enactment, and ostensibly to protect the land holdings of the Malays so that they would not easily sell off their lands to greedy speculators and so on. But more than that, when you examine the Malay Reserve Land Enactment, the Malays were prohibited from planting rubber trees. And all of us know that during the times of British colonial Malaya, during the times of British colonialism in Malaya, rubber industry was the most profitable industry. And how is it that under this scheme, Malay Reserve Land Scheme, Malays in the kampung were prohibited from planting rubber trees? So obviously there was something wrong with this. And of course, when you put any land under that kind of title, then automatically it lowers down the value of the land. So again, we have problems with the content of the wasiat, which is why we need to look into where is the original copy on the wasiat. And until today, these people I mean, they're not interested, and none of them has said, oh, I've looked for it, I couldn't find the original copy. Only one person did that in the national conference. The rest, they just continued as if there is such thing as a wasiat Raja Melayu. There was even a law lecturer who told the students that, you know, maybe this is kept in London, in the UK. Unfortunately for that law lecture, we've also asked our friends in the UK to look for a copy of this. No, they couldn't find it. So I'm still open. So we are still open that it might exist somewhere. So any one of us who have found a copy of it, please share with us the original source. Where did you get this original copy? Because it is very important for our research regarding constitutional law in this country. But the point is this, none of these people who have been talking about Tujuh Wasiat Raja Melayu have proven that they have seen, they have found the real copy. What you see on Facebook is that you see examples of great graphic designs regarding Tujuh Wasiat Raja Melayu, but you know, none of them is real. I mean, they have not proven that this is the original copy. Because the purpose of these people using Tujuh Wasiat Raja Melayu was to argue that the sovereign powers of the Malaysians are above the federal constitution, and this is why. For some of us, we still have to look for the original content. Because I get this attack every now and then that I don't know history. And to be fair, yes, I am not a history scholar. So whatever I give to my students, I have to be absolutely sure that it is real. Hence, this Tujuh Wasiat Raja Melayu, I'm still looking for it, by the way. So finally, with all of the problems that we have, why do we have this issue between what the Constitution says and how some people believe what the powers of the Malaysians are all about? Well, I think the problem is this. The Constitution is only a piece of document. How people understand and how people accord significance of the Constitution might be something totally different. For us, obviously, we believe in the supremacy of the Constitution because we've had the benefit of a legal education. Yeah, but for most people out there, what is the meaning of the Constitution to them? Because, for example, Professor Philip Koh shared with us a vignette regarding how one professor from UM waived the federal constitution to the FRA officers a long time ago, and then he was told that no, that's not important. So again, this goes back to the idea of what does a constitution mean to the people? Do they accept its supremacy? Because some people do not accept, do not even understand the meaning of the supremacy of the Constitution, and even regarding the limitation of the powers of the Malaysians. So some of these people, the most supreme in Malaysia is the powers of the Malaysians, which is obviously unsustainable when you look into the actual provisions of the federal constitution. More than that, I see this as a problem under Foucault's analysis of power and knowledge, because knowledge is not something which is neutral. It's not something which is impartial. Knowledge has always something to do with those in power, that those in power will always try to produce knowledge, and this knowledge is to be used to protect and enshrine their positions of power and their personal interests, so to speak. So again, this might be relevant when we address this issue as to why some people are okay and just allow the fact that there's some kind of misrepresentation regarding the powers of the Malay rulers. Next, unfortunately for us, none of these experts have ever talked about the dangers of feudalism. And I find this weird because when you talk about the powers of the Malay rulers, you're talking about history. And you cannot disregard what happened in the past regarding feudalism. For example, in UITM, we always examine Kisah Perairan Abdullah, the voyage of Munshi Abdullah, in which he accompanied the British officials in a tour of Kelantan and Pahang, and he observed and how Malays in the kampung had been oppressed by the Malay nobles themselves. So again, that was a form of feudalism. And when you talk about all of this history regarding the Malays, regarding feudalism, and so on, none of them have ever touched on feudalism. And again, when you talk about feudalism, again, we have to bear in mind that you can't just blame the Malay only, because power was shared between the palace and the Malay nobles. So I believe that it is unfair for anyone to only blame the Malay rulers. They would be unable to act alone on their own without the collaboration with the Malay nobles. So with all of these, when you look into what the law says and how it is explained by these academics, there's a total disjunction between them. Could we say that these academics are ignorant? Obviously we can't, because I believe these are academics and they've had the benefit and advantage of a legal education. But why is it that some of these people go on and on about powers of the rulers without looking at the federal constitution? So could this be a form of performativity in which they appear to be ignorant, but they're just performing a role? And so what is the agenda behind that performance? That is what I'm trying to look at right now, and it's still a work in progress. More than that, if any of these people are not interested in the truth, that is what we call the post-truth phenomenon. And this was made famous by the previous US President Donald Trump, in which there have been so many stuff talked about by members of his government, and they're not interested at all in the truth. Why they spread all of these rumors or what you say alternative facts, in the words of Kelly and Conway, was that they are only interested to continue and to sustain the narrative of Donald Trump and whatever supremacy that he was on. It has nothing to do with the truth. So I wonder whether this misrepresentation on the powers of the rulers is a form of post-truth, that these people are not interested in the truth, but they're trying to sustain some kind of propaganda or agenda. I don't know, but this is still a work in progress. To conclude, we cannot run away from Malay rules and the powers of the Malay rules. And I don't think any one of us here have any issue regarding the powers of the Malay rules, because look at history, you cannot divorce law from history. And from history, we have the institution of Malay rules, and they are here. And when you look into the writings of Dr. Aziz Bari, for example, he made a very interesting point when he said, the institution of the Malay rules is a very important check against the excesses of populism in democracy. That the politicians cannot do anything that they want just because they enjoy popular support of the majority of the people. No, there must be some rules regarding this. You don't have absolute power. And that's when the institutional rules come in to check, to make sure that there is no such thing, there is no excess of populism of democracy. So, I don't think any one of us have a problem with that. Of accepting the powers of the rulers, and even accepting that their powers are limited under the Constitution. What we have right now is this: what the law says is one thing, but how it is interpreted and how it is explained in some of these talks and ceramah and writings out there, these are two totally different things. Okay, thank you. Back to you, Prof. Lim.
Saudara Nazim, thank you. For those of us who have listened carefully to your presentation and your talking points, and for those of us who may have been a chance to glance at the chat, which I encourage people to interface, your discussion combined with Professor Andrew Harding has given us much provocative thoughts. Perhaps it's a good time now to open up the discourse and discussion for the next 15 minutes, which we have before we head towards the closing part of our webinar. I do invite all participants who are online to, if you like, put up your hand and I would recognize it, share your point of view, and make a concise observation or query. You are very much welcome. Is there anyone? While we wait for participants to generate their ideas and thought. Both Professor Harding and Saudara Nazim has helpfully, in some way, Nazim's and Harding demonstrates for us that constitutionalism or constitutional legal reasoning can never be divorced from interfacing with questions of history and also, of course, jurisprudence or the philosophy of approaching an interpretation of text and context. These are extremely challenging areas for all jurists. Perhaps upon Nazim's comments, I should now invite, before I invite Andrew Harding to respond, perhaps Prof. Shad Faruqi, you're online. Could I invite you, although you would disdain and disclaim that you are not a demigod in constitutional discourse, certainly you are a recognized public law intellectual. We would now invite Professor Shad Faruqi to make some brief comments from his perspective. Shad, over to you.
Thank you, Philip. I want to comment on some aspects of the discussion on how far the royals, the sultans, can exercise powers not enumerated in our fundamental law, in our constitution. Let me begin by saying, and I address myself on this specifically to Prof. Harding, let me begin by saying that life is larger than the law. No constitution, no matter how detailed, can encompass all the possibilities of life and all the problems that may arise, because there are always gaps in the law. So we have to accept unenumerated, non-textual, implied rights and duties. We do that in the area of human rights, for example. We proudly talk that life, the word life in Article 5, Clause 1, does not simply refer to bare animal existence, includes the dignity of life, the necessities of life, livelihood, etc. So the idea of unenumerated, non-textual, implied rights and duties, I think, is perfectly acceptable in constitutional law. If we are going to regard human rights chapter as incomplete and as susceptible to a moral coloring, the judge, and I'm so happy Tan Sri Dato Zainun is here, the judge will take the bare text of the law and add to it moral colors in the light of some basic doctrines and assumptions of the rule of law. Now, if we are going to do that to the chapter on human rights, we cannot deny that we have to do that to other chapters as well. So I think there are implied rights, there are inherent rights, non-textual rights in the working of the monarchy. May I, for example, point out to you, Philip, that the federal constitution nowhere has a provision for the grant of honors. State constitutions do. Federal constitution does not. But of course, the Yang di Pertuanagong and the federal government grant honors to so many people every year. The provision for a caretaker government is not mentioned explicitly. And as Professor Harding pointed out, there was a problem there. I mean, this is what happened actually when Tun Mahathir resigned. May I also point out that in countries like Australia, India, there is talk of the reserve powers. We all know Sir John Kerr dismissed the Prime Minister, even though the Prime Minister had a majority in the lower house, but because he was unable to pass the budget through the upper house, he was dismissed. and Fraser was appointed on the condition that Fraser were to advise a dissolution and call an election. In Pakistan, Professor, presidents have dismissed prime ministers on grounds of corruption. There were 2 prime ministers at least. I understand that at one time in India, when the report on the Bofors scandal was withheld by the prime minister, despite the request of the president, the president contemplated dismissing Sanjay Gandhi, and so Sanjay then made the report. So I believe that these reserve powers do exist. However, I cannot in any way agree with Griffith that the law is what happens. I think that is atrocious. If there is patriarchy, and if there is racial discrimination, and there is a caste system, because that's what happens, we cannot say that's the law. So I think Professor Harding himself found the answer for us. The courts will supply the line beyond which inherent or residual or implied or non-textual or unenumerated rights and duties cannot go. And it's to me quite obvious that whatever the position of the Malay rulers was or may have been in history, in 1957, at the stroke of midnight on August 31, Malaya commenced a new journey. There was a new game. There were new rules. The Constitution was the supreme law, and the Constitution cannot be displaced by history. Though history is important, the Constitution cannot be displaced by history or by custom or by the Volksgeist. Best example would be Article 182 and 183. 182, 183 now makes the rulers liable in civil, liable to civil and criminal proceedings. Now, surely in history, that was not so. So that's all that I want to say. I'm in broad agreement with both speakers. It was my privilege to listen to them. And I'm very happy that Nazim has pointed out that the Constitution is marginalized by some scholars. And basically they say that history is more important than the Constitution. And I don't think that is so. I think history is relevant, but to the extent the Constitution allows. Conventions are relevant to the extent the Constitution allows. I've been told, this is my last point, I've been told in my class, oh, there is a convention that a woman cannot be the prime minister. I said, where does this convention come from? They say, from 1957 till today, no woman has been a prime minister, so that is the convention. And I can't accept this kind of argument. Article 8 says there shall be no discrimination. 8 clause 1 and 8 clause 2. So I personally think no matter what history says a lot of atrocious things. If you have a supreme constitution, the Constitution must prevail. But the Constitution is incomplete.
Thank you,
Okay,
Rashad.
Thank
I think very, very interesting what your contribution is. And the whole constraint that a written constitution must exercise, regardless of interpretive horizons, the phrase I use, that might bring to play history and customs that may bring to bear in how a particular provision is being interpreted and construed. But the debate is joined in again about how judicial power is now drawn into construction of these boundaries. These are, of course, extremely lively issues amongst political science analysts and some constitutional jurists. How far should judicial power, an unelected body, interpret in a manner that might or might not grant power to any particular constitutional organs? I'm not here to give answers, of course, none of us could, but I would now invite Andrew to respond to this slew of comments that is going on. Andrew, over to you.
Well, I'm not sure if I should say thank you, Philip, because I think this is a very onerous task that you've placed on me, because I mean, the discussion has been absolutely amazing. I mean, I think it's so many interesting points have been brought up that it's very difficult to choose which one or which ones to respond to. But let me just briefly do it in this way. And I would love to have a much longer discussion on these points. But there is one kind of theme that seems to run through what Mohammed Nazim said. You know, right from talking about Schmidt and the power of the ruler and Kelsen, right through to his discussion about feudalism, and then Shad was talking about life is larger than the law. I mean, these are all extremely good points, but they leave us with a kind of a puzzle at the end of the day. And maybe here we can sort of focus on the 1957 Constitution and provisions like 181, for example, because I think what I get out of a lot of what Mohammed Nazim was saying is that we have to decide what exactly happened in 1957. Because it's not at all clear. I mean, it's not okay. You can say, well, independence happened, but even that is in doubt. So I think we need to look again at the whole process leading to the 1957 Constitution, and who did what to whom and why and where and how. That all needs to be unraveled. And quite specifically, since we're talking about the rulers here, on 181, I want to sort of bring this back to Hugh Hickling and other people who have argued for the prerogative outside the text of the Constitution. Now, all of those points I think are fair enough, and I think I agree with most of them actually. But we cannot have a situation where doubt about how much of the Constitution is covered by the text becomes an excuse for some kind of exercise of absolute power, unaccountable power. That simply cannot be the case, because otherwise, what was the point of reducing all this to writing in the first place? There has to be some point to it. It has to define powers in some way. Otherwise, there was no point in this entire exercise of drafting constitution. So I think while we understand that the constitutional text doesn't give the answer to everything, that's obviously the case. And Shad's given us very good reasons why that should be the case. Nonetheless, any powers exercised that are implicit or are outside the text or are derived perhaps from sources other than the text need to be teased out and argued about very, very carefully, because otherwise there is a danger in introducing a completely irrational element into the constitutional apparatus. Not everything that is outside the text exists just because I say it exists. It has to be argued, and I think there's a lot of force in what has been said, that ultimately the courts may have to decide what the extent of this is. Now, that is not easy when some people are saying, oh, but decisions by the rulers can never be accountable before the courts. I mean, this is frankly nonsense, because how many occasions do we need for these issues to be brought up and decided by the courts before people are convinced that it's possible? I mean, it is obviously the case that the courts can pronounce on the extent of jurisdiction to make a particular decision. As I said, that's not the same as deciding on the appropriateness of the decision, but the scope of discretion which the constitutional actor is making. So I would guess that the answer on 181 might be something along the lines, but I haven't, to be honest, thought about this terribly carefully, not since 1986 anyway. Might be that, look, that certain royal prerogatives are clearly codified in the Constitution. You know, I mean, the point about acting on advice, the royal assent, you cannot just dismiss those things and say, oh, well, all that's irrelevant because there's this huge area of royal power existing outside the Constitution. That cannot, as I argued, be the case. On the other hand, there may well be prerogatives, and again, Shad's given us some good examples of prerogative powers that are not in the text of the Constitution, but are not denied by the text of the Constitution. Now, if you argue, you know, that the ruler has powers to appoint people that are nowhere spelled out in the Constitution, that's deeply problematical because the Constitution is designed to deal with those things, but the Constitution may not deal with other things like the granting of honors. So I would want to read Article 181 down because otherwise, I mean, you might want to ask, well, if those powers were so important, why were they not elaborated in 181? Why is it just this sort of blanket, you know, continuance of that which has applied hitherto? I mean, how vague is that? The answer is because those things are only ceremonial in nature. They are not genuine constitutional powers. Yes, they exist outside the text, but they don't exist outside the text in order to subvert completely the text that has been carefully drafted. And I think I'll just stop at that point. That is my argument.
Andrew, very, very interesting. The point that you make about the grant of honors as a kind of interface. I remember when we were in the Nizar Zamri's case in the federal court, it was pointed out to the apex court that in the para, there is Article 10 with a long list of very honorific reference about prerogatives. But even in the grant of honors, the decision to grant or not grant has to be referred to the state exco for a grant of monies from the state consolidated fund to fund the medals and the honors. All right. So there is a constraint even on that part. And Nazim has also put it well over the issue of pardon. All right. Again, the federal court has ruled that even the fountain of prerogative of pardon, so-called prerogative, the word can maybe used guardedly, is framed by legislative constraint. I think your point you're making, Andrew, is there is that constraint. I see Shad putting up a hand. I should recognize it. Shad, over to you again.
Yeah, just a very quick one. I totally agree with Professor Harding that the prerogatives of the sultans, though mentioned in Article 181, have to be looked at carefully. Article 181 itself says, subject to the provisions of this Constitution. Now, that's very important. Subject to the provisions of this Constitution, the sovereignty, prerogatives, powers, and jurisdiction of the rulers, and the prerogatives, etc., of the chiefs, as hitherto held and enjoyed, shall remain unaffected. It's all subject to the Constitution.
True. Thank you, Shad. I remember again, I think I posted in the chat that while we were arguing the case, I attended a function at a royal house. I won't mention the state. And one of the close friends confronted me and said, I am a traitor. Why am I here? I then quietly said to him, I am loyal. And insofar my loyalty is the establishment of the proper legitimacy and boundary of HRH powers established by arguments at the apex court is far better than disquieted citizenry raising issues in the street, all right, that may cause dishonor to the royal house. I think that is my view. I see Ms. Stoddard taking issue about the Smitten reference. None of us, when we refer to Carl Smith, including myself, nor Andrew, all right, are suggesting that Smitten argument trumps analytical reasoning about the constraint. In fact, the whole experience of post-Weimar and the collapse of Weimar Republic constitution to Hitlerian demagoguery and authoritarian power are salutary. Reference to Smitten moment merely points out to us the clarity and importance of legality and legitimacy, all right? In fact, most of us are critiques of Carl Smith. The pointing out of a counter argument is merely to focus clarity in our argumentation with a strongest argument otherwise. All right. This is why webinars like this sharpens all our understanding. And this is why we invited scholars like Harding, Nazim, of course, Shad in the background to share their learned views. But of course, Cheryl's views are equally interesting. Do read the chat. Cheryl, would you like to say something more? I mean, than what you type in the chat? I would like to recognize you before we draw some closure to the discussion.
Thanks, Philip. I know how you feel because I read your work, and you know what I mean. When people change things according to expediency, everyone thinks they can ride this legitimacy tiger and control it, and then they lose out, and then the country is in a worse state. So my point was, I think when Professor Harding pointed out that 75% of Johorians say yes, the royalty should step in sometimes, and everyone was so happy with the king stepping in and saying no state of emergency and things like that. The thing is, these are all expedient. So my worry is, unlike Parliament, which we can control in some way, we cannot control the rulers.
Okay.
So that's my point.
All right.
So
Sharon.
when everyone tries to be that's my point.
Thank you, Sharon. I agree. Expediency, author of expediency cannot trump principled reasoning. One of the arguments I made in op-ed columns debating friends of mine in the public square is, I think the judiciary does play a role in trying to harmonize these arguments so that legitimate balance and equilibrium between the organs can still be established. Even if we take away royal power, we still have to deal with either a president or a governor. And as the gesture towards Kerr dismissal of Whitlam being hotly debated still, all right, is still raging. And the issue of governors, all right, of Malacca, Penang, and Sabah, of course, Sabah and is a clear case in Sarawak. These issues are lively. Whether it's royal discretions or governor's discretion, these issues are pervasive and will be perennial within the jostling of political elites. I see many comments and lively things on the chat. Unfortunately, our time is coming to a close, and I do not wish to deprive Tan Sri Datuk Zainud, our guest of honor, for the closing of these sessions and our webinar. I would like to recognize her now. Tan Sri Datuk Zainud is no stranger, a phrase well worn. Her journey from the University of Malaya through to a lifetime of public judicial legal service to the apex court has been crowned with honors and the respect given to her articulation of basic features and the vindication of long-held cherished ideals that many of us hold dear who are constitutional patriots. I would like now to invite Tan Sri Zainud, all right, to share her closing remarks with us. Tan Sri, over to you.
Thank you, Philip. Philip told me that this is going to be an informal session, and he asked me to make it simple and straightforward. But I think I shall do the honors anyway to give respect to the participants, eminent speakers in this webinar. Assalamualaikum warahmatullahi wabarakatuh dan salam sejahtera. Wabil Datuk Seri Azalina Datuk Usman Said, yang bahagia Datuk Profesor Johan Samsudin, Dekan Fakulti Undang-Undang, penceramah-ceramah yang terbilang, Tan Sri Datuk Muhammad Arif bin Yusof, Profesor Andrew Harding, Profesor Kevin Tan, Profesor Jean Philip Koh, Profesor Emeritus Datuk Dr. Shad Falim Faruqi, Miss Karen Chia Lin, Encik Muhammad Nazim Ganti Syari, dan para hadirin yang saya hormati. To be part of this seminar organized by my alma mater is a privilege I shall cherish. Datuk Johan Samsudin and his team in the law faculty have really done themselves proud, for this seminar has been both profound and provocative. Well done, Datuk and team. hearing Professor Andrew and Shad just now, I can feel the momentum going towards maybe we should revisit the case of Zamri and Nizar. What do you think, Philip? Anyway, if I were to put together the conversations we have had with the eminent speakers and participants, it would seem that we are not nearer to closing the gap, that disconnect between the accepted supremacy of the Federal Constitution and its existential reality on the ground. In fact, the searing comment by the Dean in his welcoming remarks bears scrutiny when he highlighted that the three branches of government, the executive, the legislature and judiciary, have not come up to scratch in their constitutional imperatives. Quite apart from identifying shortfalls in our constitutional duties, the question that looms large in our mind should be, why? What ails the citizens of Malaysia? Why aren't we careful, conscious, and competent in ensuring that the dictates of the supreme law of the land are scrupulously observed? I am afraid I don't have the answers to this, but I do believe that part of it is down to our partial and perhaps patchy understanding of our own supreme law. As events and case laws have shown, even though we have constitutional rights and rights of judicial review, it does not immediately make for a dynamic constitutional regime. More often than not, whole slabs of constitutions lie dormant for years, exerting little or no influence on social life. And in fact, when some important issues come into view, this pattern of obdurate resistance persisted, resulting in decisions like Colloquium. I am unable to give answers to the other branches of government as to why they have failed or that they do not have the wherewithal in exercising their constitutional duties, but I believe I'm quite qualified to say a few words about the judiciary. In the past, judicial review, this magnificent judicial power which lies with the judiciary, was mostly exercised in restrictive ways. In fact, judicial review has struggled for some kind of judicial foothold, not until real conflict bangs at the court's door and tear them open. Well, egregious though the attempt at neutering the judiciary might have been in 1988, judicial support for the idea that the 88th Amendment was inefficacious in divesting the judicial power of the Federation away from the courts was growing. While the ebb and flow of constitutionalism persisted, the clear and quintessential expression of constitutionalism was expressed in the trilogy of cases, Semenye, Indira, and Amanudo. This trilogy of cases mark the judicial trend that has developed constitutional jurisprudence and theory, specifically within the context of the basic structure doctrine, the BSD. The BSD, as you all know it, is so closely connected to judicial power. Judicial power is in turn extremely significant because if the Federal Constitution is to be looked to for a means to resolve crisis, then the judiciary, as the ultimate bulwark and interpreter of the Federal Constitution, is the only body that can give effect to its dictates. Judicial power refers quite simply to the powers of the courts to adjudicate disputes without fear and untrammeled by any sort of interference, whether actual or perceived. This power, unlike executive power or legislative power, is not spelled out by or conferred by the Federal Constitution. The judiciary derives its substantive powers from Clause 1 of Article 121 and Clause 1 of Article 4 of the Federal Constitution. The Federal Constitution does not otherwise spell out the court's substantive powers except for certain jurisdictional issues. After Colloquium, the judiciary had to bear every incursion into its judicial powers with fortitude. Now is the time for the judiciary to make loud and insistent call to arms. All the trilogy of cases did was to give effect to and enforce the provisions of the Federal Constitution while at the same time jealously guarding judicial power. You might ask this question, why is this important? It is important because otherwise a weak judiciary held to ransom by curtailing legislation would be powerless to act in times of crisis, especially constitutional crisis, leaving those affected by such crisis without any effective remedy. So to the question as to whether the Constitution matters, I would give it an emphatic yes. It matters more than ever before, where in recent times we have had 3 different governments in the past 3 years, where coalition government falls and are formed again with varying permutations faster than the virus can mutate. Evidently, democracy has its weaknesses if left wholly to the vicissitudes of politics. In recent times too, a worrying trend had started to emerge where it might seem that crisis might not be dealt with in as strong a manner as was done in the trilogy of cases. This declining trend started with the strongly divided decision of Malaysian adalah Ketua Pengarah Immigration. This case was primarily concerned with the travel ban, which challenge was purportedly insulated by an ouster clause. As such, ouster clause was challenged on constitutional grounds. This was arguably the first of such challenges in history, as prior to that, most challenges involving ouster clauses were dealt with on the basis of English administrative law. Reading Malaysian with respect, one would have difficulty in locating the ratio decidendi within the majority judgment. Abdurrahman Sebli, FCJ, delivered a judgment which suggested that the reading afforded by the majority in Colloquium was correct. His Lordship then went on to hold that the ouster clause could validly restrict judicial scrutiny by excluding judicial review remedies because it was affected by federal law. And all the while, His Lordship says that this is distinguishable from the trilogy of cases. Malaysian is the first decision in the series of judicial decisions exhibiting the declining trend that seriously deviates from the powerful ratio decidendi established in the trilogy of cases. In my view, the deviation in Malaysian is disquieting for the impact that it has on emergency powers. The bone of contention is Clause 8 of Article 150 of the Federal Constitution, which is a constitutional ouster clause inserted by amendment. Recent High Court decision, which I believe were discussed in this seminar, will quite clearly upheld the constitutional validity of Article 1508, premised on the decision of Malaysian. So there you go. However, the good news is that Malaysian is also the source of two strong dissenting judgments delivered by the Chief Justice Tunku Maimun and Nalini Padmanabhan FCJ. The two dissenting judgments illustrated the importance of Clause 1 of Article 4 of the Federal Constitution, especially in relation to Clause 1 of Article 121. It was articulated clearly that Clause 1 of Article 121 must be read harmoniously with Clause 1 of Article 4 of the Federal Constitution, which would then avoid a literal reading of Clause 1 of Article 121 in the untenable way suggested by Colloquium. The strong minority in Malaysian moved to strike down the ouster clause as invalid and effectively renounced the validity of the ouster clause. It was also reasoned, for my reading, that Clause 1 of Article 4 effectively housed the basic structure doctrine, and in that sense, the minority in Malaysian reasoned that the BSD is our law and that unconstitutional amendments can be struck down. If the minority decision had been the definitive decision, then arguably Clause 8 of Article 150 would have not seen light of day. Another decision rendered post-Malaysian also reflects a poor understanding of the judiciary's powers of review and of its mighty powers of check and balance in the inherent design of the Federal Constitution. This is the majority decision of the court in Robin Jyoti. With respect, the case does not warrant discussion because it was subsequently reviewed and quashed for valid reasons by another panel in Nivesh Nair and Mohan Datuk Abdul Razak bin Musa. I have been informed that the appeal is to be reheard eventually, and so the fate of Clause 1 of Article 4 and Clause 1 of Article 121, the powers of the judiciary remain to be decided. The latest and final installment in the BSD series of cases is the case of Zaidi bin Kanapia versus ASP Cairo Farul bin Rizwan. In this case, the court was to answer the question whether Section 4 of the Prevention of Crimes Act 1959, as amended in 2014, violates judicial power. This is because it was alleged that the provision that bound the magistrate to mandatorily order remand without the benefit of discretion, subject to certain procedural requirement, was unconstitutional. The majority of the court, led by Vernon Ong, FCJ, effectively held that these were certain guidelines to be followed for a magistrate to order remand. Hence, there was discretion if they were not followed. The minority, comprising the Chief Justice Tunku Maimun and Rosaria Bujang, FCJ, held that the magistrate was reduced to a mere rubber stamp, and clearly there was a violation of judicial power against the grain of the trilogy of cases. The Chief Justice also reasoned that what is actually basic structure doctrine in India is ingrained in Article 4.1 of the Federal Constitution as the doctrine of constitutional supremacy. This important pronouncement has taken the trilogy of cases to the next level of reasoned judicial progression. Meanwhile, the intensity of the debate continues. What can be discerned from this mishmash of decisions is that, one, it is arguable that the political influences of the other branches of government were pushing a stronger view, or some might even say, sovereignty or supremacy of the executive legislative bloc that is prevalent in jurisdictions like Malaysia, which are built on the Westminster Model. Two, constitutional literacy is imperative now more than ever. We can begin by having common law rights which are scattered over a wide range of decisions stretching over decades, be gathered and examined to see how far they are coherent and whether they can be expressed in more contemporary terms. It is crucial to know which direction the law will be nudged. Sometimes neither law or logic will compel one decision or another, but a keen understanding by the judges themselves of constitutionalism is important. Thus, it is the individual judges' views of the public interest that will determine the outcome. What is also clear is the role of judicial activism in carrying out the judiciary's constitutional duty of upholding the federal constitution and the basic structure which underpins a functioning democracy and the very idea of the rule of law itself. As such, the return to secure constitutional foundations as laid out in ASEAN and Government of Malaysia, where Lord President Sufyan made clear that, quote, the doctrine of parliamentary supremacy does not apply in Malaysia, hence we have a written constitution. The power of parliament and state legislation in Malaysia is limited by the constitution and they cannot make any law they please, is made possible by judicial activism as a legitimate exercise of the court's judicial function, particularly in the cases that have been laid out above against any attempt at a direct attack at the lifeblood of the judiciary itself. At the end of the day, I must admit that there is no guarantee that constitutionalism, as is manifested in the independence of the judiciary and the separation of powers, will continue to stand the test of time. At least there is no guarantee that it will, if the judiciary is not vigilant in defending the very fundamental structure of the constitution itself. Only time will tell if the vicissitudes of political interference, the ambitions of a government, or the curtailing of a misbehaving judiciary in the eyes of its would-be executive warlords or overlords will once again threaten the very fabric of democracy, the rule of law, and the constitution. For now, the constitution, though seemingly wounded in 1988, has prevailed and has been seen to be vindicated through the ingenuity, activism, and zeal of some members of the judiciary. We would do well not to forget the past, lest we be destined to repeat it. However, we should be a little comforted that the winds of change have brought about a zip-gist of constitutionalism. Much more can be said, but time does not permit. Notwithstanding this, I am sure that the fruits of our deliberations for the past few days about whether the constitution matters and the lessons for our continual journey in Malaysia will be invaluable. Thank you.
Tan Sri, your articulation of issues that concerns all of us, your balanced view about, within bracketed, of course, judicial activism as a protector to what is the value of constitutionalism is indeed salutary for all of us. We hope that we could get a copy of your text, and with your permission, we would like to be able to publicize it as a statement of your ongoing journey as a jurist and as someone who loved this nation and loved the country, and how in your own stewardship of your high office, no doubt you are the first to admit that not all your decisions are unquestionable. As Andrew Harding said that perhaps we can revisit Nizam and Zamri, and you laugh about it. Remember, we had an ironical moment when you sat as a non-executive chair of a body, and then suddenly Dr. Zamri came and replaced you as a chair, the very man that you, in a way, vindicated his office.
Yeah.
It's one of the ironies of human life, but that is more an anecdotal comment. None of what you say is personal. None of us have personal grist for mill. We are only concerned that all of us exercise our intellectual honesty. All right. We can honestly make an honest mistake in reading, but there should be honesty that opens up what you have used a very interesting phrase, constitutional design. All right. The whole issue of design and interpretive norms to support such a design so that the country that we care for and love would continue to grow regardless of political elites. We shall endeavor to do this. Your encouragement to the University Malaya on behalf of the Dean, who will definitely be listening to this, and of course, Prof. Shad, who has to exit for another commitment. Therefore, I took on this task. I can see in the chat all the endorsement of what you say, not because of only who you are, which of course very compelling, all right? But I know that you have many challenges. You are extremely committed, even post-retirement. But we thank you for being with us and spending time sharing your wisdom and insights. With those remarks, I would like to thank you, Tan Sri, for giving us the remarks. Thank you so much.
Thank you, Philip.
We have come to the closing of this webinars. We have only opened up the conversations. There's an unending journey for all of us. All right. The word vigilance has been used by Tan Sri Dato' Zainun. All of us need to be vigilant. All right. We are well aware of Edmund Burke's command. Evil will flourish if good, virtuous men and women do not exercise vigilance. So all of us need to practice the virtues of constitutionalism. All of us need to impart it. All of us need to persuade our friends, our stakeholders, and all of us need to remind our political actors and constitutional organs that if they do not abide with those limits, they endanger even their very own existence. It is even for their own pragmatic goal that they should support constitutionalism, legality, and legitimacy. With that, I also want to give a promotional comment. We will soon be advertising. In February 9th, we will have a Tun Sophian Memorial Lecture where we have a distinguished world-class jurist and retired Constitutional Court Judge, Dr. Dieter Grimm, who will address us on these very issues on the 9th of February at 4 p.m. We will be broadcasting the event soon, and we hope to see the very same people who has persevered with us both at these sessions and through the Facebook access. With those remarks, I'd like to now close the whole webinars. I'd like to thank all my learned presenters. Andrew, thank you so much for giving your time and being so... You want to say something? Yes, Andrew, say something before we close. You put a hand up. Do you want to say something?
That was supposed to be applauding rather than putting a hand up. I appreciate your remarks, Philip, as always.
Thank you so much, Shad, your support for this event, without which we would not be able to carry on. Saudara Nazim, your robust and a commentator put well, courageous taking on the gauntlet of fellow academicians. This is what academic autonomy is all about, isn't it?
Yes,
The
indeed.
willingness to not be competitive for the sake of an end in itself, but to be able to take on a discourse robustly and to take rejoinders and to be able to face up with documentary, evidential, notwithstanding historiographical contestation, my favorite word. So with those remarks, I'd like to thank all of you and participants and other learned commentators whom I have no chance to call on to make comments. Dr. Majid, your presence and your great eminence is recognized. Loganathan, other senior practitioners who have listened in. Once again, Tan Sri, especially for yourself, thank you for joining us, gracing the occasion. Good night, everybody, and God be with us, and God bless Malaysia.
Thank you.